I don't know, after hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
Flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Friday night. Hope everyone had a great week. Hope you guys all have a good, fun, safe weekend. Weekend. Thank you everybody for coming. I've already seen Jonathan, Phil, Cassidy, RC Cross. We have Fred, each and everything. Thank you guys for coming. Thank you guys for commenting already. Yeah, we got some fun court tonight. Before I get started, I need to think. I was memorizing his name before it started. Hold on. His name is La Casa del Ritmo. I probably butchered that, but he sent me the thumbnail clip. That's clip number 2 on the video. First clip is my favorite game I like to play is Are You Going to Jail or Not? That's our in-person case in Judge Washington. That's case number 1. Second case will be the thumbnail clip. And then we got Judge Perkins, a couple other judges come in. We finished with Judge Asanta. We got a good lineup for tonight. Hi, Annette. How are you? We have a good lineup for tonight. Anyways, my second favorite game that we just started is whose courthouse is behind me? We're going to start doing this. This is a multiple choice answer, though. There's a lot of judges that we watch that are in this courthouse that's behind me. But at the end of the video, I'll let you know whose courthouse this is. This one isn't as easy if you don't know it. If you know it, it's easy. But if you don't, not so easy. All right. Before we get into the video, you already know what to do. Like and subscribe. Do your jump kick backflips. I gotta remember to look at the camera. I'm always looking at the chat. When I'm talking, I gotta look at the camera. Like, subscribe, do your jump kick backflips if you would like to, and I'd very much appreciate it. My link tree is in the description with all my pay apps. Please and thank you. I know I already said thank you to the people that donated last night, but I generally save my thank yous for my lives. So, Mimi and Angelica, thank you so much for your donations. You get 2 rounds today of thank yous. All right. Go.
In order to report to community corrections and give him an opportunity to report where he lives locally instead. And so far we have received no reports, with the allegation being that Mr. Hayes was unable to report because they didn't know where to send the reports, when in fact the referral came directly from this court.
That is correct, Your Honor. As we were stating, and I will repeat it at the last hearing, Mr. Hayes had contact.
Hearing at this time, Ms. White.
I'm sorry?
Are you moving forward with the hearing at this time?
Yes, we're moving forward with the hearing.
All right, thank you. Ms. McDuffie?
Your Honor, I was just made aware of that about 2 seconds ago. So if there was a need to have any witnesses present from any of the other the location, either where he was ordered to go test or from community corrections, I don't have that. I could attempt to get someone here, but I think the issue is a lack of communication, so I'm not sure what they would be testifying to given his explanation.
Well, I don't.
I'm sorry, Your Honor. Let me speak with Mr. Hayes. I think we will be pleading guilty with that situation. My fault. That is totally my fault, Your Honor. He is pleading guilty with explanation.
All right, thank you. Mr. Hayes, we're here for a hearing today, and you have a right to have that hearing. And at this point in time, you can continue or you can choose to not. If you waive your right to have the hearing, then there's a possibility that you could have your bond revoked. Do you understand that, sir?
Yes, Your Honor.
All right. And the reason we're having a hearing is because I've heard your explanation already once and I didn't like it. You understand that?
Yes, Your Honor.
You still want to waive your hearing, sir?
Yes, Your Honor.
All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You may lower your hand, sir. All right, is it true, sir, that you have not been testing at community corrections? At least you weren't up until the date of our last court date, which was November 30th, 2023?
That is correct.
All right. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Now, with this explanation.
I believe we started the explanation. I know Your Honor wanted me to continue. I think we were cut off because you didn't want to hear it anymore. But
No, you were cut off because we're here for a hearing, and either we need to have the hearing or you need to admit we don't.
Mustard. That's your daily chef secret. Mustard helps burns. I don't know if it helps it actually heal faster, but it helps to burn a little bit. At least that's what everyone says. I don't know if it works.
Go into explanations before that occurs.
that is correct. I'm sorry. So as Mr. Hayes was stating, he was confused. He had contacted the place in Muskegon and he had the referral sent. They had contacted here and he was waiting on a response from there. The person at the Muskegon testing place was waiting on an email from 14B and they told him he couldn't test until they had that. So he was waiting on that. We have talked extensively about how he should have contacted 14B because he was to continue testing at community corrections. He did call 14B after the last hearing, called probation, got the community corrections information and was told by probation that he should have had those results sent to community corrections. So he now understands what to do. He was in inpatient treatment during some of that time. He does have test results from KPEP where he was in inpatient treatment at. He does have those test results. I did ask that he I did ask him today for the proof from KPEP that he was inpatient. He said KPEP said they will be happy to email or fax over any type of paperwork needed from the court, but he does have his testing results. And I do want to point out to court, we did talk about last night and today that he could be facing some type of jail time and he is here knowing that.
Between last hearing and this hearing, we still don't have testing.
We did discuss that. And he had said he did contact, he still thought he was waiting on them. I did ask him why he didn't go test between now and last week.
Last week we had a visit.
Yeah.
Because the people there, they didn't have, I found out when I called the 14B here, estimate director of community corrections, they told me that the results should be sent to community corrections. That's what the results are. They don't come to the probation department. That's where the mistake
He
was.
thought these results.
These results are supposed to go.
Okay, we still have.
That's the best answer right
Your
there.
Honor.
The best answer. Thank you, Leah.
They need to be sent from Muskegon.
Okay, we still have some confusion. Your Honor.
They need to be sent to-
Mr. Hayes is gonna need, Mr. Hayes and I are gonna need to sit down and go through this step by step. He is still confused between the Muskegon testing results and how to do community corrections, how to get those to community corrections and how to get everything set up from Muskegon to here. So we just ask for your indulgence why he and I get this straightened out.
Oh. Who did you talk to at probation?
I believe it was the probation officer that was on this case, the lady that gave me, that sent the referral to
Which
DNA.
agent is that, please, sir? Do you know?
I don't know her name now.
Is anyone on the line from probation at this time? Stop. Ms. Johnson,
Good morning, Your Honor.
morning. Do you know if you spoke with Mr. Hayes regarding his lack of testing per chance?
I did
Mr.
not speak with him in regards to that, Your Honor. I know that I did send the initial referral to DNA in Muskegon, but that was the last involvement I had on the case.
And is it possible you can contact Community Corrections to find, well, he still is not testing. And I pretty much warned him about this when he was on the call from the last hearing, and yet we still don't have testing. The agency that you did the referrals to, is it possible you can see if anybody's available? I know it's lunchtime, so there may not be, to see what is going on from their end in terms of this testing.
Sure, I can reach out to them, Your Honor.
All right, thank you.
You're welcome.
I'm gonna pass this and handle my failure to appears. See if we can get a response from them. That's gonna drive what I'm gonna do here today. If I find out from them that it has nothing to do with them not receiving any documentation and you haven't shown up, then I will handle it a different way.
I understand.
State of Michigan.
All right. Now what we just fast forwarded about, it was about 20 minutes of court. I just fast forwarded. I am going to apologize. I had this guy's clip last week. That's how I knew this guy was going to be in court. It was a part of another video though, and I deleted it. So you didn't get to see him last week. Now, this guy seems to be doing everything right. He is testing. He's not testing at the place he's supposed to be. He was told to test a place, and he tested somewhere else without getting permission from the court or probation. So he didn't have permission to do it, but he was still testing. But they weren't sending the results, and he was promising that it was clean. Now, over the last week, this was last week, he still didn't do that. He was still testing where he was the other place and didn't change, didn't get permission. So that's why he had to show up in person, because we're actually in, we're actually in a, he's in trouble, right? He didn't do what Judge Washington asked him to do. But he was still testing clean, so he says, and so his attorney says. And he does have a rookie attorney, so his message hasn't been coming across very clearly. But still, McDuffie's not going to let that slide. Judge Washington's not going to let that slide. So now he's in person to potentially go to jail. Now that I just gave him all that backstory, is he going to jail or not doesn't make any sense, because he knows he's not. I already ruined it for everybody. He's not going to jail. But he's in trouble.
The court will recall the case of the state of Michigan versus Kevin Hayes, case number 22F00924 and 21FB1673.
McDuffie.
I'm
Sorry, Rich McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Kevin Hayes.
Kevin Hayes.
Thank you. All right, there is no one that will be available at your testing, at the testing site where he lives until 4 p.m. today. So that was one piece of information that we were able to find. The second piece of information is that he spoke with our coordinator in the probation department, who gave him the contact information for community corrections so that he could talk to them to find out how they need to send the information over to them for reporting purposes. It appears that piece is where we did not get this completed at. And so, having said that, do you need more time to talk to your client before I go to Ms. McDuffie to see what she has to say? He looks like he wants to say something to you.
I don't think that's going to help. Fred, but I appreciate it. I did ruin the ending of this.
If I may. Your Honor, yes, Mr. Hayes is still a little bit confused. He thought that if he was to contact community corrections,
Anyone else love that Judge Washington's on her phone right now? She's texting right now while getting testimony. She's texting.
have those testing results sent down here. He didn't know within this past week, he should have been testing at community corrections. So although when he was told in court to test last week, he thought he contacted probation and asked where to have those testings sent. He called community corrections to get the email and the information to have his test results from Muskegon sent. So as I stated earlier, I really need to sit down with Mr. Hayes, explain the process, explain that he needs to test at community corrections here until everything is set up in Muskegon.
I think he understands that.
I think he does now.
Ms. McDuffie?
Your Honor, just that I hope Mr. Hayes understands that we're not trying to set him up to fail or trap him. This is important, not only for following the court's orders, but because of his own history and because of the allegations in this case. I don't want to see Mr. Hayes getting in any more situations like this, where he may be under the influence and acting aggressively, possibly fueled by that. I want him to get some help. That's what this is all about. So it's difficult for us to be able to proceed and figure out what we're doing with the case when we don't know if he's even able to assist in his own defense, if we don't know if he's using. I'm glad that he had the initiative to go seek some treatment, I guess, during some of this time that we haven't been able to get these results, but we can't see that yet. We have to take his word for it that he was in treatment. So I'm glad he at least recognizes the need for it. I do too. I want to see him get help with this and to stay out of these types of situations. So that's all from the people. I don't know to what extent his confusion. I'm not going to speak on it because I don't know about his confusion. I just want him to understand we want help for him. I do.
All right, she's correct. That is the goal of this whole process, but I think he understands that part. All right, I'm gonna do one more opportunity. You don't follow my orders this time, sir. I'm gonna put you in jail. Okay? You gotta go test within 24 hours. Here, you gotta go test today at community corrections. So you're gonna have to prepare an order for you to go to community corrections. You probably cannot. 2:30, I think. What is it? Do you think 2:30? That's fine. All right, so you can probably go there after 2:30 today.
Sam.
Okay. Yes.
If I may. So just so Mr. Hayes can hear me on the record and to be clear, he is to test at community corrections from now until the testing is set up in Muskegon.
Right.
And then those testing results are to be sent to community corrections here.
The Muskegon test results
Are to be sent
to community corrections.
Here.
Correct.
Here. I'm going to take them in my office and explain it again. Okay.
Are we ready to proceed on the pretrial today or no?
No, we need an adjournment for the pretrial.
January 11th, 2024 at 9:00 a.m. I will continue otherwise. If you don't go test today, sir, I'll issue a bench warning then immediately. Thank you.
I was muted the whole time. I was muted the whole time. All right. Yeah, I mean, that happens. It happens. What I was saying thank you again to Del Ritmo that sent me this clip. This is the clip of the week, in my opinion. Get your Coca-Cola and your popcorn, as Judge Stevens would say. I'm not going to say a word during this entire thing. I'm not going to pause it. But, whoo, right, Tommy? The perils of being live. But yeah, I did learn from the best. Feckin' demon. All right. Again, kind of tough to watch, but very entertaining at the same time. All right, let's go.
Where's my attorney? What am I supposed to do? Well, the judge is going to talk.
All right.
Thank you, sir.
All right. Damian Sassi, I'm Judge Vigorito here to explain your charge, your rights, and your options on how to get out of jail. You are charged with a third-degree felony, assault causing bodily injury to a family member. This is a criminal charge based on the sworn statement of a police officer. It does not mean you've been found guilty. You are presumed innocent unless proven guilty, and you'll have an opportunity. Don't interrupt me. Let me finish. You'll have an opportunity to talk to an attorney before making any decisions about how to handle your case. Now, I'm going to go over your rights under the Constitution, and then I'm going to talk about your bond amounts and your options on how to get out of jail, and you'll have an opportunity to ask any questions you have. Okay, I know you have some questions. I'll be glad to answer them, okay? In any criminal case, you have the right to remain silent. You don't have to make any statements about your case. If you give up your right to remain silent, whatever you say can be used against you. You have the right to hire a lawyer to represent you. If you don't have the money to hire your own attorney, you can request a court-appointed attorney. Mr. Sassi, do you want a free lawyer to help you out, or do you want to hire your own lawyer?
I don't have any money.
Okay, so you want us to give you a court-appointed lawyer then? Okay. If the police or the prosecutor want to talk to you about the facts of your case, you don't have to talk to them about it if you don't want to. If you choose to talk to them, you can end the interview at any time. You have the right to have a lawyer present during any discussion with the police or prosecutors about your case. You also have a right to a reasonable amount of time to talk with your lawyer before making any decisions about your case. Now, this is a felony. On a felony, you do have the right to request an examining trial to argue that there's no probable cause, no reasonable basis to charge you with a crime. You could talk with your lawyer about whether that option makes sense in your case. If you're not a U.S. citizen, you need to be aware that a conviction of a criminal offense can affect your immigration status. And lastly, if you're not from the United States, you do have the right to request that we contact the embassy of your home country and let them know that you're here. Would you like us to contact the embassy of any other country, Mr. Sassi?
I'm a United States citizen.
Sounds good. I have to ask that to everybody, so I had to ask you, okay? All right, so your bond amount is set at $5,000. Now, the reason this is a felony is because you have previous convictions for assault, family violence, and therefore it bumps this up to a felony. Your bond was originally recommended at $15,000. I reduced it down to $5,000 because of the particular allegations involved and because of your limited financial means. So in order to get out of jail, you need to go through a bail bondsman or a lawyer. A bail bondsman will often charge around 10%. In this case, it'd be around $500. You'll have an opportunity to use a phone to get a hold of friends or family and try to bond out. If you do bond out, besides showing up for all your court dates, you are required to comply with an emergency protective order, and I'll explain what that means. This is for the protection of Xandra, and it prohibits you from doing four things, okay? First of all, you're prohibited from committing family violence against her, which is already illegal. Second of all, you're prohibited from communicating with her or members of her household or family in a threatening or harassing manner. So if you have any contact with her over the phone or in some other way, you just need to be careful how you communicate with her. Thirdly, you are prohibited from going within 200 yards of her residence at 500 Cherry Lane in Cedar Park, Texas. And it's my understanding that's not where you live, and so it shouldn't be a problem staying away from there.
Can I go and get an attorney so I can explain?
Hold on, let me finish, okay? And you just take 200 yards away from 500 Cherry Lane in Cedar Park. And lastly, you're prohibited from carrying a firearm or ammunition. This protective order is going to last for 2 months until February 7th. You're going to get a copy. Make sure you read it and comply with it, because if you violate it, it is punishable by up to a year in jail. What kind of questions you have? Go ahead. I know you have some questions.
I would like an attorney so I can go ahead and explain everything. I have physical evidence on me that I was doing the bathroom in my house at 4507 Silverstone Drive.
I don't want you to go into the facts of the case. This is a recorded proceeding, and whatever you say can be used against you. I can't discuss the facts of the case with you without your lawyer present.
I want to be in front of the judge as soon as possible. I want to plead my case right now. I want to go in front of the judge.
I can tell you that I'm familiar with the allegations, and I know what you're talking about with regard to the things on your hands and all that kind of stuff. That's stuff that you need to talk to your lawyer about, but I'm familiar with the statements that you made to the police officer about that. So, and I took that into account in terms of setting a bond amount, which is why I actually reduced your bond amounts by 2/3. Okay, I don't want you to have too hard of a time getting out.
I have a good job, and if you could just give me a chance, I'm willing to wear an ankle monitor. I won't run. This is a big mistake, and I want to work. Please, can you please give me a chance?
Well,
I work at Sonic off of 35 and William Cannon. This is my first time being responsible and get my life together. The things that are going on in my home are really sick and inappropriate, and I tried to report it, and my sister lied and beat me to the punch. I haven't done anything wrong. I know my past, and I've done wrong, and I've admitted my crime and done my time. But this is the one time I've never done anything wrong. Please, Judge.
I see from your criminal record that you've made a turn, and I think that's great. Now, listen, I don't have the option to give you a personal bond to let you out of jail for free. The law does not allow me to do a personal bond on a felony domestic violence case. You're going to have to post bond, which is one of the reasons why I lowered the bond, because I knew you were going to have to hire somebody. And I
don't have anybody do it.
You don't have any family that can help bond you out?
No, my dad and my sister they're using synthetic drugs and they're having sexual intercourse. And I try to tell my dad that they don't need to do that. And then they try to kick me out. My residence and my dad share the same residence at 4507 Silverstone Drive. My dad and we argue a lot. But when she's around, she's always manipulating him and giving him drugs. And she don't want me there because Zandra just got out of jail for hitting her boyfriend.
Okay.
And assaulting her.
Let me stop you there. You're gonna have to talk about that with your attorney. I don't mean to cut you off, but I just can't discuss with you.
I'm gonna lose my job, sir. When am I gonna speak to an attorney?
So your attorney will be assigned to you, if not the end of the day today, by the next business day, which is going to be Monday if it's not today. Okay, and then they'll reach out to you shortly after that. Do you have friends or family that can help you? You said you have your father that might be able to help you, right?
Can you call my father? Because he won't talk to me right now.
Well, I can tell you that we've already.
I have 2 checks that are at Sonic. I can go pick up, but I pick them up because they're my name.
Mm-hmm.
I mean, I can't run. I'm doing good out there. I don't want to run. I want to settle this right. Is there any way you can please give me a chance? Please.
Well, I'm giving you every chance I get. I don't have the option to give you a personal bond. I can't let you out for free. The law will not allow me to do that. I'm actually going to lower your bond to $4,000. A bail bondsman, if they want to do it for 10%, would be $400. You'll have an opportunity to use the phone in just a little bit to get a hold of your friends or family and see what you could do to help bond you out. Okay. If for some reason you're not able to get out in the next couple of days, then your court-appointed attorney is going to reach out to you, and you can talk to them about what they could do to help bond you out in some way. Okay. What was important to me is, number one, that you show up for all your court dates. And number two, that you abide by the conditions of the protective order, which means staying away from your sister's house and not communicating with her in a threatening or harassing manner, not carrying any firearms or ammunition, okay?
Sir, all this took place at my residency, and I asked her to please not come over. And I was doing the bathroom. My dad thought I was intoxicated because he was under the influence, and he freaked out. she started panicking. She thinks that he's her girlfriend. She's freaking crazy, man.
Talk to your lawyer about that. And if you want, listen, besides talking to your lawyer, you certainly have the right to call the police and make allegations if you think that someone's violating the law, and you have the right to do that. Okay. So you can talk to your lawyer and talk to the police if you feel that it's something that needs to be reported. Okay.
So this is a 3rd-degree felony drop to a misdemeanor.
So when you go to court, your attorney will negotiate with the prosecutor what they're willing to offer and whether they're willing to drop it down to a misdemeanor.
I honestly didn't touch her because my dad stepped in between us. She pulled out a black baton on me. I said, listen, if you hit me, I'm going to call the police. I already have a record as in. She's like, you know what? I got something for you. And she ran outside, hit her baton in a gray car.
About that. I don't want you making any more statements about the case. You need to talk to your lawyer about
I have
that.
nothing to hide. Who do I talk to? This isn't right.
Well, your court-appointed attorney is going to reach out to you in the next couple of days. If you don't bond out before then, you will have an opportunity to use the phone momentarily to call your family or friends and see what you could do to bond out, okay? I'm doing everything.
It didn't even happen. Why don't officers look at evidence on people's bodies? Like, why don't they do that?
Discuss that with your lawyer, okay?
Yes, sir. I'm sorry. I don't mean to overwhelm you or
All right, it's all right. I understand this is an emotional.
I never thought anything like this could happen. I thought it was like only on TV where people get wrongly accused for things. You know what I mean? I'm scared. Like any other time I know I'm gonna go to jail because I either broke into something or stole something or hurt or robbed somebody. Sir, this isn't me. She's not even my family. I mean, don't even have the same last name. She don't even live with us. By law, she's not even my family member.
Talk to your lawyer about all that, okay?
I will lose my job.
All right.
Good luck.
All right, man.
Thank you, Judge.
Hey, look, I remembered to unmute that time. I know Biggin already left. For everyone that came over from Biggin's channel, thank you so much for the raid. Thank you, Biggin, for the raid. If he goes back and watches that clip, I really hope he does. Yeah. What do you guys think about that one? Right? For everyone that joined, little game that I started playing. Name that courthouse. Whose courthouse is that? It's multiple choice. There's about 20 judges in there, so if you just name one, you'll probably be right. All right. And as always, when I go on full screen video, my Wi-Fi dips down. All right. Next clip. But yeah, thanks for everyone that came by. If you haven't liked already, please do so. If you haven't subscribed already, please do so. All right. Let's go on to the next one. No.
Judge, this is City Prosecutor Detroit Diachiku Mason 43471. I'll be stepping in for Lou Geringer for a moment.
Thank you so much. All right, Mr. Geringer. Who's next? I have Willie. Is Willie here? Willie.
That's Garwood, Judge.
Yes, I'm here.
Let's get Mr. Willie Garwood. City of Detroit. This is Willie Garwood, case number U66499-523. Appearance for the record, please.
Yeah.
For all the new people out there, I'm a really big fan of Judge Perkins. I watch him every day. He's usually in my videos every day.
Yes, Melinda Cameron appearing on behalf of Mr. Garwood. Mr. Garwood, state your name for the record, please, sir.
Willie Garwood.
Your Honor, this date and time scheduled for a show cause. Would ask that the show cause be set aside at this time.
All right, I'll set aside that I'll enter not guilty for this guy gives a $0 fine. Is this going to be a plea?
It is to a 3-month delayed sentencing, Your Honor, to open on.
Mr. Garwood, can you raise your right hand, sir? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
You can put your hand down, sir. Do you understand, is this what you want to do, plead guilty to this today?
Yes.
Or do you understand the maximum possible penalty for this offense, 93 days in jail and or $500 in fines?
Yeah, is it still the go 3 months without?
Yes.
Yes, sir.
Yeah.
Okay, and then if I violate that, then okay.
And then it comes back. You understand that you have an absolute right to a trial?
Yes.
And do you understand, Miss Cameron went over your other advice and rights in the breakout room, did she not?
Yes, the 3 months correct without no tickets or anything.
Yes.
Okay.
You understood that, right?
Yes, correct.
Your advice and rights, you understood that, right?
Yes, correct.
About that.
No.
You know, by taking this deal, you're gonna give.
Is that not a stock image of her kitchen? Or a stock image of a kitchen? That's what I always thought it was. I thought it was just one of those generic green screen choices you could pick. But you guys are all saying you love her kitchen, so maybe I'm wrong.
Those rights up. You understand that?
Yes. So I just do good for 3 months, correct?
Sir, stop interrupting the court. Will you
Oh, I
please?
apologize.
How many times do you have to say it? Thank you.
I think she's talking to
Sir,
me.
Sorry.
What do you need to know? Do you want to go back in the breakout room?
Oh,
and
no,
speak?
it's fine.
So why do you keep asking the same questions?
I think I'm hearing wrong. I apologize.
Are you hearing wrong? I need to make sure you're hearing right.
Yeah, I hear you correctly.
All right, you understand that Miss Cameron went over your advice and rights in the breakout room, did she not?
Yes, correct.
And you understood them, right?
Yes, correct.
Any questions about them?
No.
You understand by taking this deal, you're going to give them up, right?
Yes, correct.
Anybody offer you anything other than what's been stated, like the 3-month delay
No.
and a $240 fine? Anybody offer you anything other than that?
No, sir.
Let me draw your attention back to July 31st, 2023 at around 12:40 a.m. in the city of Detroit in the area of Larned and Brush. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes, in the parking lot, correct.
Were you drinking out there?
In a vehicle, sitting in the vehicle.
And what did you have to drink?
It was an open bottle. I wasn't drinking.
And what was it, liquor in there?
Yes, correct, and they poured it out.
You weren't drinking it. It says he's consuming alcohol near the dumpster. He says he's in a vehicle. It doesn't line up.
Judge, he's pleading guilty to open alcohol.
Alcohol-related violation, consuming alcohol. Were you consuming alcohol, sir, or not?
No, I was in the vehicle, but I'm pleading guilty though to.
All right, I'm not gonna take this because he's all over the board. We'll set a trial date.
Thank you, Judge.
You know, it's just, you act as if you don't want to, if you were drinking it out there, then you were drinking it out there. If you weren't, then you weren't. Now, what were you doing?
I was sitting in the vehicle and they basically with people, they was out there drinking. They basically took us, charged us all at the same time. So,
and you were out by the dumpster.
I was in the vehicle by the dumpster, correct, inside the car, yes.
And you weren't drinking though?
No, I just got charged with everybody else.
All right, very well. Trial date is gonna be February 12th, 2024 at 9 a.m. All right, come back then and we'll get some resolution then, all right?
Yes, thank you, Judge.
All right, have a safe, happy holiday season, sir. Best of luck to you.
You too.
All right, two things. I live alone too. I've got a 2-bedroom apartment and I live by myself. Also, Peach, I hope you're doing well. I know I've talked to you a few times today, but I'm glad you're back and I hope you're well. Just feel like I had to give you a shout out. Deborah Baker, This actually, I've got a question for you specifically, and I didn't play that video in this clip. It's about taking pleas and how somebody can take a plea and time. All judges do it differently. Judge Simpson is where as of the LawTube community, if you don't admit to the crime and you beat around the bush about it, he doesn't accept your plea. Judge Perkins is the exact same way. Some judges will take a plea when you half-ass it. When you just say, like him. It's like, I wasn't drinking. They just charged us all with that. I just want to take this plea and get it over with. Some judges will accept that. Some judges won't. What is the proper way? By law, is it different state to state? Yeah. The plea was an open container. No, they charged him with, all right, well then never mind. So he had to plead to an open container. Okay. All right. Yeah. All right. Then yeah, my opinion doesn't matter because of your vote.
Next matter.
This guy is wild. Hopefully you guys haven't seen this yet, because I need some opinions. I need to know, because I watch court all day, right? So I think I have one way of thinking when I come to watch these types of things. This guy's got some conspiracy theories. But I wouldn't accept this plea if I was this judge. Since we're on the subject, Deborah Baker, I would not accept this plea.
For the court is People versus Christopher Lee Johnson. It is filed 23S30636FH. Mr. Johnson appears by video for the Montcalm County Jail. His attorney, Mr. Shear, is present in court. I've had the opportunity to speak with Mr. Shear. My understanding is Mr. Johnson wishes to take advantage of the plea offer. He would plead to count 1, which is possession of methamphetamine. We have an agreement that he would serve 14 months in the Department of Corrections. We are waiting. He would not. We are dismissing the individual.
Correct, Mr.
That is correct, Your Honor, and Mr. Johnson is on parole, so this would be a consecutive sentence.
Correct.
All right. And then, Mr. Johnson, that's your understanding of the agreement?
Yes, Your Honor.
All right, raise your right hand. I'll have you sworn. You solemnly swear from testimony you're about to give me the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, you can put your hand down. So the charge of count 1 is possession of methamphetamine. It's a 10-year felony and or a $15,000 fine. Do you understand the nature of that charge?
Yes, Your Honor.
And then do you understand the maximum penalty is up to 10 years?
Yes, Your Honor.
Do you understand, Mr. Johnson, if you go forward with your plea, you won't have a trial of any kind? Is that what you want to do, is waive your right to have a trial?
Yes, Your Honor.
Waiving your right to have a trial means you'll waive all the rights that come along with the trial. I'll describe those to you now. It means you're waiving the right to be presumed innocent of the charge. It means that you're waiving the right to confront any witnesses that would be called against you or to call your own witnesses. It means that you're waiving the right to testify at a trial or not to say anything, and the trier of fact couldn't use that against you. And it also means that you're waiving the right to have the assistance of an attorney at a trial. You have Ms. Shear, she could stay with you throughout a trial and even post-trial if need be. Are you waiving all those rights that would come along with a trial, sir?
Yes, Your Honor.
All right. 2 more things you'll be waiving we have to discuss. The first one is this. If you waive your right to have a trial, then you're also going to be waiving your right to claim at a later date and time that it was not your choice to enter a plea this morning. Do you understand that?
Yes, Your Honor.
Okay. Waiving your right to have a trial means you'll also be waiving the right to claim at a later date and time that there were other promises or threats or inducements to you, except for those that we've already announced on the record this morning. Do you understand that? Mr. Johnson, do you understand that?
Your Honor, can I speak?
Yeah, go ahead. You might want to check with Ms. Shear though. We don't want you to say something that could make things worse.
I don't, no. It's been brought to my attention that my attorney and also from my family that Mr. Valet has a biased opinion about me and refuses to give me a fair proceeding. Mr. Valet was the prosecutor for Brandy Jones' case that she just got sentenced to 12 years.
Mr. Johnson, why don't we stop a second? Mr. Valet is a prosecuting attorney. So
Yes,
whether
exactly.
he has a bias or a prejudice against you, first, I don't know that I buy that, but even if he did, he's the adversary here. So he is the part of the executive branch or not offer anything that they would like to do as the prosecuting attorney's office.
So I can't speak.
Well, you can clear it with Ms. Shear, but I think you're just in general, you're kind of barking up the wrong tree because the offer that was placed on the record today is, I must see this 1,000 times, both in Ionia and Montcalm County. In charge with meth, they dismiss the habitual offender. Happens every day.
All right, yeah. I'm good.
Well, let's just circle back then. I was posing to you that what's troubling you was the question, do you understand that if you waive your right to have a trial, then you're also going to waive your right to claim at a later date and time that there are other promises, threats, or inducements? That's a long way of saying that if you go forward with your plea today, you can't come back later and say, hey, wait, there were other promises that were not placed on the record. For instance, if I pled, if I'm on probation, they're going to give me a $30 voucher every month so that I can go buy cigarettes. Something like that, right? Are there any other promises or inducements to you?
No.
Okay, let me put it another way. Are there any other, what you would perceive as threats to get you to enter this plea? Mr. Johnson, you seem troubled. Listen, you don't have to enter a plea. You can have a trial.
I guess. No, Your Honor, there's not. No.
Do you want some time to talk to Ms. Shear? I don't want you to rush into something. If you'd rather have a trial, I'll schedule it for a trial. And you can explain your side to the jury, and then the jury will listen to both sides, and then they'll make a determination. Or you can have a trial in front of me, and I'll listen to both sides, and I'll make a determination. Whatever you're most comfortable with. You don't have to enter a plea.
No, Your Honor. I'm good. I'm going through a lot. I apologize.
So let's circle back then. Again, have there been any other promises or threats or inducements that are getting you to enter this plea?
When it takes him 10 seconds to answer a simple question, this is when his attorney jumps in and says, we need to talk about this. Let's ask for an adjournment. We need to talk about this. He's not clear about it. And he's obviously has some conspiracy theory in his head that the prosecutor's against him. Yeah, the prosecutor's against you. The judge just said that. Doesn't matter who the prosecutor charged before you. Hey, my best friend was charged by this prosecutor. That means they can't prosecute me. No, that's not how it works. But this should be pushed off. This plea deal should not be accepted. That's what I think. Now I'm going to call it Deborah Baker again. Am I right or am I wrong? But he's obviously unsettled by this.
No.
All right. So let me think. So we left off with all right, all the things he's waiving. So then the next thing is, Mr. Johnson, even with a plea, you'll still have a form of appellate review available to you, and that's called leave to appeal. With leave to appeal, you can hire your own attorney. If you couldn't afford one, you could request a court-appointed attorney. Do you understand that?
Yes, Your Honor.
All right. So let's talk about that charge now. Mr. Johnson, the charge of possession of methamphetamine.
Guilty.
All right. The information says this occurred on or about September 18th of this year in the township of Eureka, county of Macomb. Is that the correct date and location?
Yes, Your Honor.
On that date and location, can you tell me in your own words what you did to be guilty of that crime?
I got pulled over. And he searched the car and he found a bag with some residue in it, and I'm guilty of possessing meth.
All right. So driving a car, was this your car?
Yes, Your Honor.
All right. And found a bag. Where did they find the bag? Do you know?
The passenger seat.
Okay. And in the passenger seat, it had residue, and was the residue methamphetamine as far as you were aware?
Yeah.
Okay. Mr. Blake, anything else on the facts?
No, Your Honor.
Ms. Shear, how about you?
No, Your Honor.
All right. Mr. Johnson, again, has anyone else, or has anybody, let me put it this way, has anybody promised you, threatened you, or done anything else to you to get you to enter this plea?
How can you tell someone's a Law Talk with Mike fan without them telling you they're a Law Talk with Mike fan? They quote his clips. It's right there. Crazy Cat. Thank you for being here. We all love Law Talk with Mike.
Excuse me?
No.
Okay. Has anyone besides Ms. Shear, that's her role as your attorney, to tell you the different options and what she thinks could happen, or what you'll ask for, or what the people would ask for, but has anybody else besides Ms. Shear said anything to you about what your sentence will be as a result of entering this plea?
No, Your Honor.
Okay. Mr. Blay, are you aware of any other promises, threats, or inducements?
I'm not.
How about you, Ms. Shear?
No, Your Honor.
Mr. Blay, do you believe the court's complied with the court rule for taking a plea?
Yes, Your Honor.
And Ms. Shear?
Yes.
Okay. Mr. Johnson, do you have any questions now that we've almost completed this process?
No.
All right. Mr. Johnson, the last question I have for you. Do you want the court to accept your plea to this charge of possession of methamphetamine?
Yes, Your Honor.
All right. We'll accept your plea.
We're here
I
for
want.
hearing
Oh
today.
no! I tried to pause. I just rewound it so far. That was all the way back to the beginning. I was agreeing with you. Yeah, I agree.
That means somebody from probation will be over to talk to you. Once that's completed, Ms. Shear will get a copy of the report, and she'll be able to go over it with you so we can check it for accuracy. That report generally takes about 4 weeks, so we'll have a sentencing date about 4 weeks from now. Anything else from either side?
No, Your Honor.
No, thank you, Your Honor.
Okay, you're all set. Thank you.
We have Mr. Coffin.
I think we lost like 30 seconds. You saw what I wanted to show, where I didn't think that guy should. Not. I don't think the judge should have accepted the plea. That was what I wanted to show. And he was accusing the prosecutor of being discriminatory. Sometimes words are hard. All right. We're going to the last clip. Yeah, this is the last clip. We're going to the Judge DeSanto clip. This is no one's fault. Again, now that we all watch Law Talk with Mike, and he always blames I'm looking so bad right now because I can't remember her name. Somebody help me out here. I don't know. Oh man, Natalie, thank you. It's always Natalie's fault. I'm friends with Natalie. We're from the same place, and I just blanked real quick. But yeah, so I want to start saying it's No's fault. Because he always says it's Natalie's fault. This is No's fault. So blame him for losing brain cells every time I show a Judge DeSanto clip. If you haven't done it already, please like and subscribe, do jump kick backflips, and jump over to Natalie D's channel and subscribe to her as well. Because I'm a jackass. I've been on her channel and I couldn't even remember her name. Just a minor lapse of memory. You know what? Let's just play the clip. This is fun, right?
I'm just talking to the individual out loud. So, no, you're okay.
I do.
Can
you hear me?
Okay. Yes, I'm sorry. I'm having some issues now with my file system here. Okay, so let's go on the record in the Holdings LLC versus Terrence Smith and all occupants 18395. And then there's also the matter of the city of Riverview 201105 versus Terrence Smith. So
we mess with each other all night long. It's never your fault. You're allowed to mess with anyone in the chat. If I let people like Pseudo and Heineken come in here and hang out, and no, if I let them come hang out with us, everything's free game. As long as you're respectful.
First, Ellison, please.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff MSR Holdings LLC.
Okay. And Mr. Smith, just please remember you're in court, and so if you're chewing gum, that's not appropriate. And then Mr. Smith, your name for the record, please.
Terrence Smith.
Okay. And then Mr. Meldy, your appearance, please.
Your Honor, P83783 on behalf of the city of Riverview, Michigan.
Okay. All right. So first, as I did indicate, before I put all of you in a breakout room, Mr. Smith filed this objection and garnishment in July, and based upon some flaws and inefficiencies with the MyFile system, it took a little bit of time for that to get and then scheduled. So, and in the meantime, it appears as though the judgment with the city of Riverview has been satisfied.
Correct.
Correct?
Yes, actually, this case was scheduled for July, this objection to the garnishment, but it was adjourned because Mr. Smith had called the court and stated that he was in a car accident.
Correct. September 15th.
Okay, so this was on the docket in September.
That was good.
Okay.
I
And then
appreciate that a
adjourned
lot.
out. Okay.
I appreciate that.
All right, and so Mr. Smith, are you withdrawing your objections to garnishment as it relates to the city of Riverview since that matter has been satisfied?
I do not, even though he's saying that he's been satisfied and there was a proper way to go about this. I believe my objections to the garnishment is valid. They have the wrong address and the wrong person, and I was still garnished.
Your Honor, the
Okay, sir,
objection
please
I
get
have.
further gum. Just one moment, Mr. Smith, I've already indicated to please get rid of your chewing gum.
Yep.
Okay. And so, and so you want to proceed with the objections on the city of Riverview matter, even though you have paid your judgment in full.
Yes, even though I paid a judgment in full on someone else's behalf, because like as I stated, it was the wrong address and wrong race of person.
What do you mean you paid it on somebody else's behalf? I don't know what that means.
As in, when I went to Riverview and asked them why I was being garnished, they told me it was for an ambulance drive to the hospital, and the ambulance drive itself was only $900. So I was also overcharged for the ambulance drive. And when I called them, they said the person on file came from Balmy Apartment 1, and it was a white male. I am a black male, and I lived at apartment of Balmy 3.
Okay, well, sir, let me just clarify something. if you're objecting to if you are objecting to the garnishment, there's a certain basis by which you can object to the garnishment.
Okay.
If you are objecting to the judgment, there's a different procedure that needs to be followed.
Okay.
And that's what that sounds like it is here.
Okay. So when filing the different be filed, would that bring me and the creditor back to court to settle the garnishment matters?
It would bring you back to court to address the judgment, which ultimately could address the garnishment. But first, the first step is to address the judgment. And that issue is not properly before the court. And I understand from your perspective that since you and the attorney are both here, that perhaps it could be reviewed. However, the attorney doesn't have all the information that he potentially would need to have because there was not any notice regarding anything as to the judgment. So therefore, we can't proceed on that issue, and you'd have to follow the procedure accordingly.
Okay.
So as it relates to that, there doesn't appear to be a valid objection to the garnishment on that matter, because it appears as though your issue is with the judgment itself.
Yes, ma'am. So question, if my issue is with the judgment itself, it being not valid, the law is still able in some ways to garnish me, even though I'm making claims that the judgment of the garnishment is not valid?
You had an opportunity to participate in the previous case, Your Honor. The judgment was entered in 2020.
Yeah, I didn't have an opportunity.
Whoa, put your swords down. Ask. Because I filed paperwork that said it was unjust after I paid it in full. What? Does anyone understand what's going on? I actually do know I understand what's going on, but that question it didn't make sense. There was nothing to answer, and Judge Asanto was just staring at him, and then the attorney jumped in and just was like, "No, you're not going to use this BS as a way out of this." This guy, I know someone was saying soft sit on a clip or two ago. This guy's not a soft sit, but I have a feeling he would be very easily pushed into that direction from just how he talks, how he sounds, how he's easily persuaded. All right, let's continue.
The underlying judgment.
Sir, do you live in Canton or do you live in Wyandotte?
I live in Canton, and during the time of this judgment, I was homeless. I didn't get any warning or any sort of hearing about this. Or a judgment, so a default judgment was just made on my name.
Again.
Well, hold on, sir. Let me just say this, that the law requires the creditor to send the information to the last known address they have on file.
Okay.
It is not the responsibility of a creditor to track down individuals that may have moved and not changed their address.
Okay, that's
So
understandable.
I understand that there can be hard times that people fall on. I certainly do. However, when did you relocate from Wyandotte?
2018. The court has evidence of me being evicted from there with my previous case with the same case I have today. On the evidence there will show that I was evicted in 2018. Which what I'm trying to say is, even I understand the consequences of not answering court hearings and things of that nature. Is just I never received the hearing. I never received any paperwork about this. I didn't receive paperwork until I was able to establish the new home. Then I received paperwork saying that my checks is going to be garnished, and that's why I filed the objection to begin with, because I didn't know anything. Morning.
Sir, when did you move to Canton?
2021.
So where were you in between 2018 and 2021?
Homeless and in and out of homeless shelter.
Okay. So, sir, the address that this was served upon was your address in Riverbank, and I can understand that you're saying the court has record of your eviction. However,
Fish on, I don't know what I don't know what that means. And Mike, what do I say before my videos? Are you talking to me? Like what my intro says? Is that your question? And then yeah, Fish, I have no idea. This is just my timely pause I gotta do on every video. Hope everyone's doing well. If you haven't liked and subscribed already, please do. And what I say at the beginning of my video is just a clip from a live, from one of my first lives where some guy had a very long excuse about why he didn't have a tether. So, and Heather clipped it. Heather does all my behind the scenes stuff. She clipped it and just said, yeah, no, it was just the end of a story. And yeah, it was just the tether story might be, I don't know. I see it every day and I still don't know what I say. The tether story might be probable or something like that. That's what I say. And then, yeah, the fish comment, yeah, I don't know what that fit. Yeah, I do miss you. Come up, ask more questions.
I had no
Mr. Mel,
I'm sorry.
let me finish, please. Please let me finish. Velo Law Office did not have that information. And I don't know as to what extent was taken to locate where you were residing at that point. I was not on the bench at that time. Oh, no, 2020, I was on the bench. 2018, I was not.
Your Honor, if I may, I don't want to address the previous judgment because again, the Michigan court rules prevent him from attacking the underlying judgment, but he was personally served. I'm looking at the proof of service right now. On July 27th of 2020, he was personally served.
When and where? I didn't have any domicile and during.
Counsel, hold on, Mr. Smith, just a moment, counsel. That is what Mr. Smith's issue is because it's saying that the individual that was served was white.
Mm-hmm. Correct. I understand that. But
Mr. Smith is not.
Again, he had the opportunity to participate in the case. He was defaulted. That case is well beyond.
Counsel,
I understand what you're saying.
Mr. Smith is indicating that he was not served. This shows personal service was obtained on a white male on July 27th of 2020. Mr. Smith has indicated he was not even residing there. So the whole judgment was moved forward based upon this personal service. So if Mr. Smith were to file something regarding the judgment, there's an issue.
That's a separate matter. We're here for the garnishment today, which has been satisfied. He's attacking the underlying judgment again.
Counsel, I am very well aware of that. I'm very well aware of that. I went through this specifically so that Mr. Smith could understand what the procedure is and the fact that he cannot proceed with attacking the judgment today. I've already stated that. What I'm also stating is that Mr. Smith.
I'm sorry. What is shrimp sauce? I know I'm not talking. This is dead air. I'm racking my head what shrimp sauce is. Peach, you got to tell me what shrimp sauce is. Fish sauce, clam sauce. There's a lot of sauces out there. I've never heard of shrimp sauce. Cocktail sauce. If that's what you're at, say. What the yummy? Hold on. No, wrong one. I paused. I can't even read it. The yummy sauce they give you at Chinese restaurants. Sweet and sour sauce? What Yoga Pants said? What did Yoga Pants said? Cocktail sauce. That's not shrimp sauce. I thought you were about to blow my mind with some southern sauce that I've never heard of. Man, like a lot of you know, I have been duck sauce. That's actually what I thought she was talking about was the duck sauce. But I have been in the restaurant industry. Well, I haven't done it for years, but for 20 years, and I've never heard of shrimp sauce. But if it's cocktail sauce. All right, it's not cocktail sauce. All right. I don't want to pause up everyone who's going to be watching this video later. So we're going to come back to this because I need to know what shrimp sauce is because I don't think that's a thing. Peach, I love you. You're awesome. But I don't think shrimp sauce is a thing. Unless it's yum yum sauce. Yum yum sauce. I don't know what yum yum sauce is. So is that a southern thing? I know you're from Georgia, obviously. That's the grossest thing anyone's ever. No one does that. I know you were just trying to be funny, but that was gross. All right. Let's go. I don't know what yum yum sauce is, but
has stated that not only does this process server or the notice certificate of service say that he's white, so does the ambulance information. So his statement is that he paid the judgment of somebody else and that it's not him. And I understand from your perspective that your client's been made whole. But perhaps Mr. Smith has a valid claim that it wasn't him in the ambulance ride. However, Mr. Smith, there is a way that has to be done, and I cannot initiate that way. That has to be done through another matter.
Yes, ma'am.
So that is why there's not a valid objection to the garnishment because the garnishment was proper. Whether or not the judgment was proper is another matter. That is not before the court right now.
Okay.
Sir?
Yes, ma'am. Question, even though
I just Googled it.
As you stated, I can come back at a later date to file the proper procedures to address the manner in which the judgment has proceeded and me basically just restating I believe that they garnished the wrong person, correct?
Sir, that's crossing the line for what I can tell you because that would be giving you legal advice.
Oh, that's what I said.
Court statutes that address relief from judgments. That's all I can state. I can't tell you anything else beyond that.
Okay.
Okay?
Yep.
That's horseradish. No, that's cocktail sauce. Cocktail sauce is not what she's talking about. Ketchup and horseradish. All right, so cocktail sauce is ketchup, horseradish, Worcestershire sauce, and a little lemon juice. That's how restaurants make cocktail sauce. That's not what she's talking about. She was saying a shrimp sauce. So I just looked up shrimp sauce. And there is something that's a shrimp sauce. And it's what someone else said that was the yum yum sauce. It looked like a mixture between cocktail sauce and mayonnaise is what it looked like. So I don't know if that's what you're talking about, Peach. But it's a thing. So I was wrong. 20 years in a restaurant and I was wrong about cooking something. But I don't claim to know Southern cooking. I'll never claim to do that. My internet's dropping. I gotta play.
Okay, so Mr. Melby, I believe you are all done with this matter.
Is the court going to enter that satisfaction of the judgment?
Oh, that's on my file. Just take notes, please. Yeah. I will review that, counsel. I'm sure it's in my system to review.
All right, thank you, Your Honor.
Thank you. Have a good weekend.
You too.
Okay, and so we are on the record. My file's frozen, by the way. On the record, we're still on the record now, Ms. Allison, in your manner.
Your Honor,
And so
his objection to my garnishment as well. I did file a written response to it, Your Honor.
I have lost all track of what we're watching. I don't even know what's going on. I'm looking up shrimp and sauces for shrimp right now. Carrie, I was just looking up that. I just Googled Nikado. Is it Nikado sauce? Is that what you want me to Google? I don't know. Hopefully, I edited the video correct and we fast forwarded a little bit, and now we're back to the case. And I'm going to let it play for a little bit because I've been pausing a lot. So let's go.
So, Mr. Smith, you filed an
When I
objection
looked
to
it up,
garnishment.
a restaurant came up. So now that makes sense.
Yeah, I believe it's happening the same way with the first case with the creditor. I have evidence showing that the landlord had a worker there that vandalized B&E and stole my things. I also have numerous letters stating that I don't know why, but I even told him that I was joining the military, but yet he still proceeded with the eviction. I understand the consequences of me not making those payments while on active duty, but I will say during the time I was not allowed to make payments because of basic training. But I will work with the courts and with the lawyer as best as I possibly can to get this resolved.
Okay, so let me just clarify a couple things because counsel, my file system here is frozen. I just want to throw it out the window, but so I don't have access to that document. I have your response, and I have the order, all that's paper, but the other is on my base or on base. And so when was the judgment in this matter entered?
Your Honor, I'm actually looking at the register of actions because we weren't the previous attorney on this matter. So in this matter, it was a landlord-tenant action with a money judgment. It looks like the original judgment was February 26, 2018. It said judgment entered by consent as to him, judgment by default as to all occupants. And then in April, there was an order filed for eviction. And then in May, it looks like there was a motion scheduled. And then the motion was served in May. And then there was a hearing held on the motion, Your Honor, on May 23rd, 2018. Then there was.
Counsel, what was that motion?
I don't, Your Honor, that was from the previous counsel. I'm just going off of the register of actions. It looks like there were filings going back and forth in regards to the order of eviction. So I do believe that he participated in this action, Your Honor.
Do not threaten me
But I
with a
don't
good time.
definitively.
I love North
because unfortunately I don't have the hard file for the underlying judgment, Your Honor. It says an order entered to stay the eviction on 6/21 of 2018. And then on August the 6th of 2018, they came back and a motion was granted for the eviction. So this
Yeah,
file,
I also find that a little weird as well. During that time, that's when my Army unit decided to intervene. And at that point, I didn't know what was happening after that when they intervened. All I know is they sent letters to the landlord and to the courts about them having BHH having payment problems with the military. That's what from what I can remember.
Okay, well, and there is the Civil Service Members Relief Act, there is that. However, it appears that that issue was raised. There was a hearing, okay, by Judge Colmack on August 6, 2018, order regarding hearing. The stay placed on the matter on June 4, 2018 is hereby lifted. Defendant indicated he'd be able to appear after July 29th and August 6th. Plaintiff may apply for an order of eviction after August 13th. The plaintiff shall submit an amended judgment reflecting the original balance, $2,936.48, plus an additional 6 months, which is $700, minus the payment made of $1,860 for.
I am 4 hours away from Asheville. Asheville is one of my favorite cities that I've ever been to. I've been all over North Carolina. I'm so jealous. I'm so jealous of that. Thank you for. I'm coming down. You know what? Screw it. I'm going to drive down tonight. I don't know where you live. I'll just drive all over the state. It's not like it's a big state, right? I can, drive all around it in like a couple hours and I'll find you. All right. I'll be there by midnight.
A new total of $5,276.48. Amended judgment shall be submitted under the 7-day rule. And so, sir, that judgment was submitted. And it appears as though you had been attending or participating in this matter as there were hearings that were held.
Yeah, that's when I got out of basic, I went to AI and I was able to obtain a phone to attend.
Okay, and as I think I've indicated before, sir, the court does appreciate your service to our country. And but there is an amount that was due and owing. As to whether or not that judgment should have been entered or not, it appears as though it was addressed via hearing and there was a stay of proceedings because of that. And so there is a judgment that had been entered. And
you're just narrowing down my search.
If you did not provide a forwarding address whereby which you could receive your mail, they don't know where else to send it, so they send it to your last known address.
Yeah, that's like I said, same thing. After returning home, I became homeless because of that situation. I was homeless for about 2 years. And during that time, I didn't know what was going on with my legal proceedings.
But did you contact the court to find out?
I turned 40 in March. I'm older than I look. I have been blessed with, I look like a kid always, which is why I don't shave. Because when I shave, I really look like a kid. But yeah, I turned 40 in March.
I didn't have a phone. Like I said, during the time, I was a homeless veteran living in a homeless shelter.
Okay, but you knew which court it was in, you could have,
I had no at the time of me getting to the homeless shelter, it was actually the police escorted me from Wyandotte all the way to downtown Detroit. So during that last very days that I was in Wyandotte, I was in downtown Detroit for about almost 2 years at the homeless shelter. So I was not getting anything. I didn't have any sort of money to even travel to get information. I tried contacting my unit. They never reached back out to me during that time of hardship. It's now being rectified by my army, but again, like I said, I will work with the courts and the lawyer as best as I can to try to see what will be the good options for all of us.
okay. And sir, I can understand that you had some tough times that you had to endure.
Yeah, and I had a payment issue. The army was not paying me correctly to send my landlord money, and they did send a letter stating this, and I believe they did send the court stating that they are figuring out the money situation with me so the landlord will be paid. It's just that the army is a hurry up and wait situation, and my landlords didn't want to wait that time any sooner, and it kind of drove me to be homeless.
Well, so I don't know if that's necessarily accurate. I mean, there's a balance there, right? I mean,
yep.
But so Ms. Ellison, do you want to enter into a payment plan with Mr. Smith?
Not at this time, Your Honor. I did tell him in the breakout room he's free to reach out to me just because I'm sure he would have to look at his sorry, I'm so sorry.
What's your daughter's name? I'll give her a shout out.
Your Honor. He would have to look at his payment schedule. He was saying he was contesting the underlying validity of the judgment. So in the breakout room, it made it seem like he wasn't, didn't want to really deal with it. He's free to reach out to our office. Your Honor, today I'm just asking for you to deny the objection. It looks like it was a state of Michigan tax return. It's 900 and 900. I apologize.
I know I'm going to get a lot of shit for pausing this video so much because I'm interacting with the chat. People hate this, and I don't know why. It's a live stream, right? But Peach, we're all so proud of you. At least I am. I know BK is. And everybody in every chat, every single weekend, people have been asking about you for weeks. And I'm glad you're back. I'm glad you're healthy and you're doing what you want to do. I'm very happy about that. Keep up the good work. That's all I got. I'm just proud of you. And I wanted to send you a message saying that.
I think it was like $918. We're just asking for you to deny the objection and we will keep the garnishment.
So Mr. Smith, these are not funds that are protected funds, correct?
Today one more time, protective funds at my federal, my federal income?
Meaning that, so your funds are not exempt from garnishment, correct?
Possibly not. I do pay school. I have school debt, child support debt, car loans, and bills.
Okay. But sir, when I'm asking about whether or not your funds are exempt from garnishment, it's whether or not they're not disability based, correct?
No.
Your Honor, I will say state of Michigan income tax garnishment is not anything that would be prohibited from a garnishment because it's from the state of Michigan.
Correct.
I've never been more embarrassed for highlighting the comment.
You don't have any bankruptcy proceedings pending either, correct, Mr. Smith?
Do not.
Okay. And the judgment has not been paid in this manner. And the garnishment was not improperly issued. And so, and it doesn't say that the balance is incorrect. So, and there's not an installment payment order. And so the court has to deny your objection, sir, because they are not valid based upon the court rule and, the law.
Okay.
And I understand you had some concerns with the validity of the judgment, but again, that's a different procedure. But it also doesn't sound as though.
Peach, we know VK is your biggest fan. He hasn't stopped talking about you in 6 weeks since you've been gone. He's been talking about you nonstop. We know. Stop rubbing it in our face, VK. We understand. You're welcome, buddy.
You have the same issue in this matter that you did the other matter.
No, I believe I was living there. I did leave the home and inform the landlord that I was going to the military. He was okay with it. I guess what I find weird about it is he knew I was in the military and he still decided to evict me, which that's the only thing I find. He agreed and was aware of me joining the military, but months after me leaving, after telling him, he decides to evict me.
Well, that's a separate issue, sir.
Okay.
And I understand what you're saying, but that's a separate issue that is not before this court.
Okay.
All right. So the court has signed the order on objections, indicating they are not valid and that the garnishee shall immediately release all withheld funds to plaintiff attorney.
Okay, thank you, Your Honor. So I don't need to do the order and submit it on my file. You already did it?
No, we already had it printed up.
Perfect. Thank you, Your Honor.
Thank you. All right. Have a good weekend, both of you.
The courthouse yesterday was Judge Middleton. That was St. Joseph County. This courthouse is the 36th district. You are in the 36th district court. You are in the 36th district court. You are in the 36th district court. That is this courthouse behind me. You are in the 36th district court. I miss Judge Bryan a lot. I miss her. But that's the courthouse behind me. Everyone got this one right. Yesterday, people were guessing crazy things. Some people got it right. At least a lot of people get, like half the people guessed Michigan yesterday. But Judge Middleton's courthouse is this old structure, and I thought that'd be a hard one. But I knew this one would be a little easier. All right, this was the end of the video. But there's almost 200 people here. I've got another video. Do you guys want to watch another video? If you guys want to hang around, I don't have anything to do. So if you guys want to watch another video, I'll just load another video. It's up to you guys. Don't worry, I'll wait. I said that because it takes like 30 seconds for your comments to pop up. Keep the party going up. Wow, it is not 30 seconds. It's about 5 seconds tonight. All right, let's see what else I got. All right, I'll give you the option. I got 2 videos ready. I'm gonna see. We have 2 videos out. We have 2 video options. They're both about 25 minutes long. First one is I've got 2 clips in Mechanico of I'm not gonna say bad dudes. Yeah, they're bad dudes. But I just love Reagan and Vincent going back and forth. So I watched Mechanico a little bit too much. So I've got 2 good clips of them going back and forth. That's video 1. Second video is a woman who is battling through a plea deal in Judge Elmore's courtroom. So it's a Judge Elmore clip. She's battling through a plea deal where the story's a little weird. Do you want a weird story or do you want bad people? We want shrimp sauce. Yeah, that's not what I'm asking. That is not what I'm asking. We all want shrimp sauce. All right, so what do we want? We want Mechanico or we want Elmore? We want a weird story that that's just kind of weird, or do we want bad people? What do we want? Both. We can't do both, Beverly. We can't do both. Peach, have a good night. I hope you're well. Enjoy your shrimp sauce. Still barely know what that is. Hopefully that's, just, a visit and not because you have to go. Mechanico, I got a Mechanico. I got a weird, I got a funny, I got a Mechanico. I don't have a funny one. It's not funny, it's just weird. So I got weird, bad boys, weird. Good night, Peach. This is 50-50. All right. You know what? No, I'm gonna give, Lolly, bad people for the win. All right, Lolly wins. I've known Lolly longer than just about anyone else on YouTube, so she wins. Sorry, guys, she wins. So we're doing bad people. Just gotta load it. What I got? All right. Here, and I was just gonna say I probably have my intro. You know what? Deal with it. You're gonna have to hear my intro again. All right, but I'm gonna play it. I'm gonna back out. Can't play my intro while I'm on camera. I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving. I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everyone doing? Happy Friday night. Deja vu? Anybody? A little bit. Deja vu. I've got some crazy court clips for you. We're gonna have some fun. Judge McConico. We have Reagan. We have Vincent. People going at it. It's going wild all over the place. We're going to have some fun. But before I hit the play button, you know what to do. Like, subscribe, do your jump kick backflips. And as always, my link tree's in the description. Let's go. I did that really quick. Maybe I should do that more often. Now, really, let's go.
Turner, defendant charged with 1 count of domestic violence. State time for a bond redetermination hearing.
Before my appearance, I just have to say this is going to be an interesting argument by defense counsel. Steve Vincent for the people, he's 71917.
And what's the defendant's name again? I'm sorry.
Turner, can I talk to my lawyer, Your Honor? Can I talk?
Just hold on.
Okay,
what is Mr. Reagan, your appearance?
Philip Reagan on behalf of Mr. Ahmad Turner, Your Honor.
Mr. Turner, state your name for the record.
Lamar Turner, Your Honor. How are you doing?
Okay. Doing well. Establish a breakout room for Mr. Turner. And
thank you, Your Honor. I appreciate it.
No problem. I just have to call the case first before we can do that.
Okay, thank you again.
You're right. No problem.
All right. On the 6th floor hallway, I don't believe we have anyone else from this camera. Is that right? Oh, he came back. I don't know why he came back. Okay, let's see. Go back. Room 1, please. Mr. Hines, all right, could you get the deputy?
Deputy? Hello? Hey, Dad.
Yes, Judge. It's the clerk, but are we having anyone else in front of this camera?
No, we are not. You're all, are you all set with them?
Yes, thank you.
Okay, thank you.
Welcome. Bye.
I clearly didn't edit this video. You can tell I was not ready to play it. All right. Hopefully I'm ready to play it now.
Rob.
This is what happens. This is what happens when I just want to keep the party going.
Mr. Reagan.
Wait, was
What's the current
McConaughey just
bond on
flying?
Turner?
$500.
No, we're going back. We're going back. We're going back. I think McConaughey was just flying. He was flying.
What's the current bond on Turner?
All right. All right, now we're cut back up. Watch McConaughey fly. Get ready for it.
Rob.
He wasn't
Mr. Reagan.
flying.
What's the current bond on Turner?
$500 cash.
I'm sorry. What's the current bond on Turner?
$500 cash. Surety it's a capious bond, Judge.
All right. Argument.
Woo. All right. As Brother Counsel said, there's a lot to this. My client's 29, Judge. Doesn't have any convictions, Your Honor. No criminal convictions, but has a lot of stuff going on right now pending. A lot of stuff over in Third Circuit with Judge Gillis right now, which he's confident that he'll be found not guilty on. But again, no convictions. In those cases, the complaints are not the same complaint in this misdemeanor DV case. My client tells me that she comes to all his court dates. She shows up, in the audience, at least, and she's very supportive of him. So she is, not a person. She's always maintained that nothing has happened that has offended her to the point where, she wants to pursue or wants to be charged, wants him charged with any of this. Now, saying all this, Judge, my client is also a diabetic. He's a severe diabetic. He has to take 4 injections daily. He's legally blind in both of his eyes, Judge, because of the diabetes. He's not getting his medication correctly in jail as well. Judge, it's $500. It is a situation where, and I explained to him, let's get this matter resolved. Let's get it resolved. And then you can have contact with her. Let's just do no contact right now. If she wants to come to you, you get that's on her, but you can't have contact with her. Let's just do it like that. Make it simple. So I'm asking for a $500 personal bond in this case, so that he's not being held on this case.
Well, I have to. Is he only in custody because of this case?
Mr. Turner, you have personal bonds on other cases in Judge Gillis?
I had bonds that I paid, but when I passed out, I had court on a 17th, on an 18th.
Listen, no. Listen, the question was, let's just stick to the question. Are you being held on those other cases?
For me coming in here, it violated my bond. So today I have to go see Judge Gillis.
So what happened, Judge? On October the 17th, he had an episode. He fell out. He went to the hospital. His tether went off. He had a tether on, but he was at the hospital. So that's why he missed this court date with Judge Garrett.
My tether never got cut off. My tether was
not cut off, but it went off, right?
Yeah. I never cut my tether off.
It went off. I didn't say cut off.
When I got here.
Okay. All right, I got you. So he is in here because of a probation violation or a bond violation?
Bond violation is mine.
On the Third Circuit cases.
Yes, Your
Honor. Okay. And he capious on this case.
Yes, because that was
okay. Now we'll get to the prosecutor talking about the Third Circuit cases. All right, Mr. Prosecutor.
Judge, and thank you. Yeah, I believe there were multiple tether violations. Actually, Judge, it's in the Odyssey. You can see it in the circuit court. So the reason why it's said, and I think Mr. Reagan kind of touched on it very superficially, and I think Your Honor can see. So the AWIM case that he's on bond for, it actually got reduced to 100,000, 10%. From 750,000, he posted that. But that case, he has multiple capiouses subsequent to the reduction. And then the second that he's on for officer fleeing third degree, he has a $75,000 personal bond tether, violated that tether, has capious history. And then the third case that he has going, the R&O and the larceny, that he has a $5,000 personal with a tether, he has capious history, and he has a tether violation. Oh, and then there's that fourth case that he just picked up in June for home invasion second degree and an R&O, that he has 100,000, I don't know how, 100,000 personal bond with a tether that he has capious history in. So it's just a pattern regarding the capious history. Now, here's the ironic thing. This case, Judge, this case, we don't even need the complaining witness in this case. Complaining witness doesn't even have to show up. This was on surveillance. He's getting convicted of this one. So, and he had tether house arrest on this one. But yet he's still going out and getting violated for the tether. So he hasn't conformed to any of the bonds. Judge, I think, yeah. So he has trials set for the AWIM in January. He's got trials set all over the place, Judge. We're just asking you to continue this one.
But he has personal bonds on those. He'll deal with the teller violation. But let me explain to counsel how this works, how cases work. Now he says,
put your hand down, please. Put your hand down.
He says they don't need to.
Put your damn hand down. That's gonna be my first coffee mug. If I ever make merchandise, that's gonna be my first mug. Put your hand down. No and no. It's always your fault. No and no. I'm glad you're here for the second time.
Complain that he's getting convicted, you know, and I'm listening to that, and I'm thinking to myself, well, the complaint is saying that, you know, she wasn't offended by any offensive touching. I don't know about what they were doing about the green light, playing headlock, playing, you know, slap around. I don't know, but if she's saying that, you know, it didn't happen, you know, she's willing to come and say that, Judge, and she's been saying that. So I don't know how he's going to be convicted of this because they have some type of alleged green light video.
Okay, let's just get to this, Mr. Ray.
Yes, sir. Yes, sir.
So as to the capious, okay.
Yes.
So, and I'm confused. So since this case has occurred, other cases have been charged, or are these other cases pre the domestic violence charge?
No, it's pre the DV, Judge. All of these cases were prior. They're stemming all the way back from November of 20 for the AWIM, January of 23 for the police officer fleeing, and then we have the June 23 for the home invasion. But he's capious. I think he capious, Judge, here 1017. He capious after that with these other cases too, and before them as well. So there have been cases. Hey, all you have to do, this is public record. All you have to do is just go on Odyssey and you can see all the multiple failures to appear, all the tether violations, all the bonds that he's on. So, I mean, it's all right in front of you. And then we have this case, which makes it 5. This is the 5th ongoing case right now. And the ironic thing was, he was given the benefit of the doubt. Don't ask me how. In the infinite wisdom of whatever magistrate ended up arraigned, they felt it appropriate, which I respect. They gave him a personal bond after knowing he had 4 ongoing cases. They gave him a personal bond on this case. And then what did he do? He failed to appear after getting that chance of a personal bond.
Court haven't heard the arguments from counsel.
Well, Judge, can I just say one last thing? And whenever I look at cases in a computer, I don't know if it's because somebody wasn't brought over to court. I don't know why. If you don't know why those capices are there, it could be a very good reason for those capices, Judge. And to use them in an argument without really knowing, just because you read it on a piece of paper and don't have personal knowledge, to me, sometimes it's a little disingenuous, because things happen in this system where people aren't brought to court when they have so many cases and they're given situations. And I don't know, Judge, I'm dealing with this case here. This case here, he was capious, and we know why, because he fell out and he was in the hospital, Judge, and that's what I want to look at. Not worried about those other cases.
When is his next appearance on this case, Madam Clerk?
17th, Your Honor.
November
13th. I have November 13th, Your Honor.
On this case, November 13th?
Retrial.
In front of who?
Judge Austin Garrett. It's a misdemeanor DV case.
When are you going? That's only all those courthouses are about 2.5 hours away from me. When are you going? If it's somewhere that if it's a time frame that I can go, I'll meet up with you. I was supposed to go a few months ago, but when Heather was here, but it fell through. She is going to be here the week after Christmas, but if it's in January and the weather's not too bad, that'd be a fun trip. I still want to do it.
A misdemeanor DV, Your Honor, where the complaint says nothing happened.
In Judge, if I may, Mr. Reagan
Now,
speaks
okay,
about-
I got you. You guys are arguing me to death right now. Let me think for 1 second. Let me think.
Okay, Judge.
All right. How many other cases do we have?
4 others, Judge. 5 including
him or today for our docket.
Oh, on the docket, not him. On the docket.
Oh, Your Honor, we have one more case.
Okay. Call that case. Deputy, come here. Get the deputy in here.
The judge wants you. Yes, sir.
All right, I'm gonna do the next case, then I need you to bring him back out.
Yes, sir.
Okay, thank you.
Just proceed.
When you watch back a video that you quickly edited and you see the little break right there, I hope I got the end of that.
What's your name?
Good morning. My name is Nathan Mason.
Calling case 230-597-8401. People of the state of Michigan versus Matthon Cortez Mason. Defendant charged with count 1, police officer assaulting, resisting, obstructing. Count 2, domestic violence aggravated. Defendant is labeled as habitual offender. Third offense notice. Today is the date and time for a bond redetermination hearing.
Respectfully, Judge Stevenson for the people.
Your Honor, break it on behalf of Mr. Mason for redetermination.
What's Mr. Mason's bond?
10,000 cash, GPS tether. You can have a one-time police escort. Your Honor, my client's 43, does have some priors, Judge. Has a prior, I believe, has a case, Judge, where he is on current probation as we speak right now, Judge, for a fleeing and eluding case, Your Honor. The complaint is his fiance. They have one child, Judge. He's actually supposed to start a program at the city of Detroit, the blight removal program this week. He's a high school graduate that lives in the city. This is a DV case, domestic situation with the complainant. So obviously no contact needs to be the provision, Your Honor. And also the magistrate allowed a one-time police escort to allow Mr. Mason to get his items so that he could have items, but he was to have no contact after that, which I would concur with, Judge. So I would ask respectfully for a reduction, 10,000 cash to 10,000 personal, GPS tether, and a no contact provision and one-time police escort.
So the defendant is on probation right now, you're saying?
Correct, Your Honor. Correct. He is on probation currently right now as we speak, Your Honor. He's on probation, I believe, for a fleeing and eluding third degree. Is that correct, Mr. Mason? I just want to be clear.
Mr. Reagan,
Yes, it's correct. Yes, it's correct. Your Honor.
you know the situation. You know where I'm going to go with this. I just don't really have a lot of patience for people being on probation and finding themselves in situations where we're getting things and children are calling. When children are calling 911, this isn't the complainant who's trying to set the guy up. And when kids are calling 911 on people who are on probation for violence against women, it's kind of a it doesn't make personal bonds doesn't make them options a lot, because it just seems as though the person doesn't respect authority, doesn't respect the confines, or it's kind of like the social contracts. We don't put you in jail but you're supposed to just, acquit yourself a certain way and stay out of certain situations. Again, mere allegations. The kid could have missaw what he saw or she saw, and the woman who had to go to the hospital, maybe it was all just a ruse. Maybe it was all make believe, fantasy, illusions. But doesn't bode well for Mr. Mason.
It just maybe it happened, but that doesn't mean that a year misdemeanor. And I'm not trying to say it's any type of low level crime. I'm just saying, Judge, sometimes we do make mistakes. Sometimes things do happen, and I'm not saying that ever putting your hands on someone is something that you should do. And I'm not saying he did that. I'm not saying he did. I'm just saying, Judge, mere allegations.
Right. At this time, you said it's 10,000.
10,000 cash. You can't afford. That's unaffordable. He's trying to work for the city. He's supposed to get a job with the city of Detroit.
That's why you got to kind of, before you get to that job interview, or before those are good jobs dealing with the demolition, remediation, and stuff. That was my family business. My dad was a construction worker, so that puts you to the middle class right there. And in order to do those things, you got to stay out of certain situations. You don't hang with certain people. You don't, where you can just get caught up in anything. Where you weren't doing anything, you got to kind of watch out for that stuff. Mr. Prosecutor, your argument?
Judge, just to add to what you guys were talking about, in addition to the probation for the fleeing and eluding, and I can understand why Mr. Reagan probably didn't include it in the record either. He didn't know about it, or probably just doesn't put his client in the most favorable light. He's also on probation for operating a motor vehicle with the high blood alcohol content. He has a bench warrant out of St. Clair Shores for resisting and obstructing. And then he has another bench warrant out right now, a fraud for non-sufficient funds out of Hyatt. So there's a little bit more than just probation for fleeing that just happened about a year ago. He's on probation for 2 convictions. He's got those bench warrants out for his arrest. And then we have an individual here who was injured to the point where she ended up needing to go to the hospital. This defendant was told not to come back to this house. But what did he do? He came back. He ended up injuring somebody. He leaves, comes back again. And then, Your Honor, as you said, there's a 15-year-old. God only knows what he was thinking. I mean, because this gentleman was in the house when the 15-year-old gets there. And what does he do? He proceeds to call the cops. We forgot about the fact that once the cops ended up showing up in an attempt to try to arrest him, had to get tased because of his non-compliance with their orders. That's how far this got.
Bond continue.
Thanks, man.
Bring Turner back up.
All right, and then Kelly Mosby is, Attorney Reagan is requesting for it to be put over until tomorrow, Your Honor. Oh, A floor, 5999501, people of the state of Michigan versus Isaiah David Evans. Defendant is charged with count 1, assault with dangerous weapon, felonious assault, count 2, weapons, felony, firearm, count 3, assault with intent to do great bodily harm, less than murder, or by strangulation, count 4, domestic violence. Today is the day and time for a bond redetermination hearing.
Thanks, Judge. Good morning. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Isaiah Evans. Mr. Evans, please state your full name for the record.
Yes, sir. Isaiah David Evans.
Okay. 1 second, please. What's Mr. Evans' bond?
50,000, 10%, Judge. Tether house arrest.
Okay.
Yeah, again, this is what happens when I rush out videos. This was only half-assed edited. There were just a lot of people here watching, so I wanted to keep going. So we have this. I don't know what to fast forward to because I don't know what's in this video. This was from about 2 weeks ago. But it's Lawley's fault. Because the other video, the weird video I had, was only one case. So it's Lolly's fault. Blame Lolly. We got 200 likes on this video? That's awesome. That is amazing. Thank you all so much. Now I gotta
Argument.
28-year-old
Chief Judge is
lifelong
back.
resident, Your Honor. Indicates to us that he lives with his mother. He was forthcoming that he does have a prior criminal history back in 2020. I believe he told us it was for drugs, in which I believe he might be on probation for, Your Honor. But works at a temp service, well below the 200% poverty guidelines. I did have a chance to read this report, Your Honor, and it comes to the point. Sometimes it comes to a point where I do understand we got to protect the community and complaining witnesses, but unfortunately, it's a juggle between letting somebody sit in jail because of allegations that people make. With what's in the report, Your Honor, I do understand that the complaining witness said if he got arrested, he would shoot her.
I'm gonna say one thing. One thing that I'm tired of seeing in comments. And I'm gonna jump on a soapbox for a moment. People that are attacking is not the right word, but people that are critical with Judge Perkins and this attorney for stuttering. I don't know if they have if there's an issue going on, but they're professionals. They've been battling this their entire life. This didn't just come up. But for everybody that leaves a comment about stuttering, no one does it in the chat. No one does it in the chat. So everyone in the chat, relax. I know all of you. But I get comments about the stuttering of Judge Perkins and this attorney right here. Don't do that. If you've never had a speech problem, if you've never had anything wrong with you, and you think it's funny to attack somebody on stuttering, it's a minor stutter. It's not even a big one that impacts anything. We all see it. No one says anything except for the people that want to, that think it's funny to say it. Don't. Just don't. He's a professional. He does a good job. Judge Perkins is a professional. He does a good job. Just stop, right? Can everyone in chat right now agree with me? Just stop. All right, off my soapbox. We'll finish the clip.
The thing about it is, just knowing somebody has a gun in the house, that's easy to say. When the police came, he came to the door. He came to the door freely, opened the door, stepped out the door without any struggle. The gun was behind a couch. The gun was behind the couch. Now I'm figuring if my client really made these allegations, then the gun would be closer to him. But actually, the complaining witness had just as much access to that gun as he did at that time. When the police go to follow up, when the police go to follow up with the investigation, no go. They go to the complaining witness's house. Nothing done. They call her. She says she's gonna be down at the precinct at 10 a.m. She's not there, Your Honor. And I'm not trying to speculate why she might not be there, but it could potentially be because she's lying. It could potentially be for other reasons. But at this moment, we have a complaining witness who didn't cooperate after the investigation. We don't have any indication from any of the officers that there was any scars, scrapes, or bruises observed. We don't have any indication that that a dog was hurt with a TV supposedly thrown on the dog. Your Honor, so respectfully, my client looks forward to fighting. He looks forward to handling this matter outside of court. I'm gonna choose not to say fight this time, brother prosecutor. He's choosing not to handle it. We ask that he handle this matter outside of court. especially that we have a non-cooperating complaining witness at this moment, and we have very little proof that this even happened, Your Honor, besides hearsay from a witness that's not even cooperating with the police. He understands there's going to be no contact, Your Honor.
Got it. 1 second, Mr. Prosecutor.
All right.
All right, again. A lot of dead time. I rushed this. I should have given my my speech that I just gave now. But yeah, I'm tired of it. I'm tired of people nitpicking on other people. I'm the one. This is my channel. Nitpick on me all you want. Don't nitpick. No, do not nitpick on the people that I'm showing. Nitpick on me. If you have an opinion on what cases I'm playing, you have an opinion on that. Don't make fun of them as people, though. Everyone's a person first, right? Yeah, okay. This video is actually almost over. I didn't realize how little I edited this video. This is why it was in my unused folder. Again, Lolly, it's your fault. Lolly! She's probably not still here. She's probably passed out by now. She's the one who told me to use this video.
Thanks, Judge. On top of just emphasizing the fact that the defendant told the complaining shooter if he got arrested, a couple of really interesting things that I think Your Honor would like to know about this. The defendant has 2 ongoing cases right now. One from 2020, one from 2023.
Lolly, you're awesome.
The 2020 case has to do with 2 counts of weapons felony firearm. And I'm sure he ended up getting a condition in that no firearms. He's got a trial up on that one in January of next year. So he's on bond at the time of this offense, Judge. Now, this other case that he's got, that's a 2023 case. That's a controlled substance case. He's on bond for that one too. He's got a 2024 trial on that one. And then we have these alleged set of particulars, Judge, having to do with the defendant and an AR-15 while he's on bond for gun-related charges. Judge, I mean, we could all hypothesize as to why the complaining witness, at least up to this point, hasn't availed herself. Maybe something having to do with the fact that the defendant previously said that he would shoot her. But with all that being said, 10%, we're just going to be asking Your Honor to continue the bond.
Court having heard the arguments, counsel, court finds that 50,000, 10% is an unaffordable bond. Court finds that, the court does not find that the bond is unreasonable or excessive. So the court has to take into account, are there any other non-restrictive ways to move this case forward? But where there is a rifle involved, there's the threat of, if you call the police, I'm going to kill you or shoot you. It's pretty tough. And I'm sorry, is the defendant on probation right now?
He is, yeah.
He is
no.
Or is he off of probation?
I'm not on probation. I'm on.
I think what defense counsel meant, he's on bond for those two matters, Judge. I didn't see any probation. He's
Okay,
on bond.
He's on bond right now. And what is he on bond for again?
In that first case, he's on bond for 4 counts of controlled substance, 2 counts of weapons, felony, firearm. The ironic thing was, when that was bound over, he was given a $50,000, 10% cash bond. He posted. So he's out on bond in that case. The controlled substance case, that the charges that he picked up this year, Judge, he was bound over. He got a personal, his trial is set for April of next year. So I wanted to just focus on, I'm sure Your Honor can appreciate, the weapons, felony, firearm, plus those counts.
Yeah, and okay, and I don't want to keep this case going too long. The thing that is troubling is that again, I don't understand if I guess if I have 2 cases pending and I got I put up 5,000 to be out and I'm working the temp service and all that stuff. How do we get here? How do we get to this situation while we got 2 cases at Frank Murphy Hall of Justice? How do we get to this? And it just seems like these are the times where one might want to be on their best behavior. If your significant other is acting a fool or just out of control, run out the house, because you don't even want the police to get caught, or there's something that you could even get caught in, get your bond revoked, or you get to, I just don't even understand how we get here. We got gun charges, and we around assault rifles and rifles rifles by the couch. And I mean, why are we here? Why are we here? I don't get it. I don't understand how we can have an active gun case, dope cases, and then we're here for some domestic stuff. Like I don't understand. I don't get it. Mr. Evans, what I'm gonna do, because you got a lot going on right now, sir. I'm gonna take a chance that you're gonna kind of get yourself together a little bit, because you're trending in a bad place, sir. You're trending in a place to go to Jackson Prison right now, because judges over at Circuit are not going to take too highly about other weapons charges while you got weapons charges and threats and all this other stuff. But I'm gonna reduce the bond to 50,000 personal, no contact, no weapons, no threats, curfew, 10 p.m., 6 a.m., GPS tether. Mr. Evans, this is it now, sir. This is it now. So good luck, sir. Good luck.
Never hear from me again.
All right. Enjoy.
Thank you.
Call the next case, please.
Say less. Say less. All right. I'm not playing another one. I'm not going to play the weird one. I've now been live for 2 hours and 15 minutes. I am old and I need to go to bed. I'm not old, but I'm going to go to bed. I've been up since 4:30. Thank you, everybody, for coming. MB, I just sent a message in chat. I hope you're still around. Thank you so much for the super chat. I appreciate it very much. It's very generous. Thank you, everybody. Thank you, everybody, for coming. If you haven't liked already, please do so. If you haven't subscribed already, please do so. If you like the channel and you really want to help out the channel, my link tree is in the description. Well, enjoy your Friday night. Don't do anything stupid. Don't drink and drive. Call an Uber. If you can't afford an Uber, call me. I can't afford one either, but I will try to help you out. I'll tell you not to drive. I don't know. Now I'm just talking out of my ass. All right. Have a good night, everybody. Until next time. Bye.